So very good morning, all the participants, rather very good evening, all the participants. So today we are going to learn how to remember the case laws. Some people still have confusion between case laws and case studies. So to make things clear, the first thing is that these case laws cover 5 marks only and case studies are different. So case studies cover 70 marks, case laws cover 5 marks. And in 5 marks, you have to study 72 case laws. And they will ask questions in between. And each case law may be sometimes running into more than 50 pages, more than 100 pages. So it may not be always possible for everyone to remember all the things. But they expect us to remember the important things at least. So that is the expectation from us. So what we have done is, for your reference, we have made this presentation and we have done some, we have highlighted some key issues and these are the key issues. And I think we have already discussed the Supreme Court case laws. Hai na? Sudhakarji, we have already discussed Supreme Court case laws.
Yes, sir. Yes, sir. We are complete.
And this PPT is already available with you.
Yes,
Hai na?
sir.
Is it available?
It is available and you have shared it again, sir.
Yes, I've shared it again also. So I'll share it here in the chat box also. Just so now, before we move to High Court case laws, regarding Supreme Court case laws, we can have a quick revision. Like this innovative industries. Can anybody explain to me 2 important features of this case law, innovative industries? 2 important points if I ask you. What are the 2 important facts? What are the 2 important things which were discussed in this? Innovative industries.
Supremacy of 138
Right.
over Maharashtra Relief Undertaking Act, sir.
Yes.
Okay.
And second is whether directors can file application after CRP.
Right. Because here the suspended
about
board of
default.
directors, they filed the application. Although it is not allowed because the powers of the board stand suspended. But still the Supreme Court allowed, this being one of the first cases. So they said, let us do it comprehensively. Let us explain all the concepts because this is one of the first case laws in insolvency. It is of 2017 and this IBC came in 2016 only. Now regarding Mobilox, apart from dispute, what was discussed? In Mobilox, apart from the question of dispute, what else was discussed? Dispute we all know that it was discussed. In Mobilox, if we take this case, Mobilox versus Kirusa Software Private Limited. So dispute was discussed at length. And whether, second question, whether this dispute is an inclusive definition or it is a conclusive definition. Yes, please. Anybody?
Conclusive?
Andy?
Conclusive?
No, it is inclusive.
Inclusive.
Actually, the Bankruptcy Law Reforms Committee, they gave a conclusive definition. They said dispute means, but when the law was enacted, when IBC was enacted, they made it inclusive definition and they said dispute includes. So from conclusive, it was made inclusive. Now another important thing, Pooja ji, for you. Apart from dispute, what was the issue which was discussed in this case? Mobilox resolutions. Yes, please.
Sir, it was regarding non-disclosure agreement. That was related to dispute only.
Any other thing which you can think of? भाई और क्या डिस्कस किया? डिस्प्यूट का तो सबको पता ही है, उसके अलावा क्या था? First was how to interpret the existence of dispute. This we all know. Then, what is the scope of determination by tribunal while examining applications under Section 9?
Hmm.
So, the powers of the tribunal were also discussed.
Hmm.
Because tribunal also has got limited powers. They can only decide on certain things. So, the scope of determination by tribunal while examining applications under Section 9, that was also discussed. And whether the word and occurring in Section 8(2)(a) should be read as or. So, this was also discussed. Then the test of bona fide dispute, whether it is open to the adjudicating authority to go into whether a dispute does or does not exist, and whether dispute exists falling within inclusive definition. So, these were the issues. So, apart from the dispute, the scope of determination by tribunal while examining application under Section 9 was also discussed. Okay. Now, next case, State Bank of India versus V. Ramakrishnan. So, what was the key issue here in this case? So, it says Section 14 is not applicable to personal guarantor of a
Personal
corporate debtor. This was the main issue. So, I think accordingly, you can ask yourself, because as soon as you read this Mobilox Innovations case, dispute automatically comes. But the examiner might ask you something different. So, we have to remember the other things also. So, the scope of tribunal was also discussed. Now, let us go directly to High Court cases. High Court we have not discussed, I think.
No, sir.
No, sir.
देखो, मैं थोड़ा सा ना अलग वे में डिस्कस करता हूँ ईच टाइम, बिकॉज उससे क्या होता है, थोड़ा सा ना मुझे भी फूड फॉर थॉट मिलता है. अदरवाइज आई विल ऑल्सो फील बोर्ड अगर मैं सेम चीज डिस्कस करता रहूं हर उसमें. सो यूनिवैल्यू प्रोजेक्ट्स versus the Union of India. So this was the first case. So what it says? So first was the issue here was the jurisdictional overreach by NCLT. So High Court determined that NCLT exceeded its jurisdiction by issuing the directive as it lacked the authority under Section 424 of the Companies Act to impose such a mandatory requirement. So this action was deemed ultra vires, the IBC 2016. Actually, in this case, what happened? As you know, when you want to establish a default, there are various options which are given. You can produce a record from the information utility. You can supplement it by other documents also. This we all know.
Yes, sir.
So the point here was that NCLT mandated that financial creditor must submit a record of default from an information utility. Now the point was whether NCLT can do any such thing. This was the issue. So High Court here said that the NCLT has exceeded its jurisdiction by issuing the directive, as it lacked the authority under Section 424 of the Companies Act to impose such a mandatory requirement. So this action was deemed ultra vires. Second point, interpretation of Section 7(3)(a) of the IBC. So it says other evidence of default are also allowed. It says the use of or indicates that submitting a record from an IU is not the sole method to prove default. So the word or has been used. And third point was the retrospective application was held invalid. So NCLT's attempt to apply the directive retrospectively to pending cases was invalidated. The court held that subordinate legislation cannot have retrospective effect unless explicitly authorized by the parent statute. So if you read this section 7.3a also, so other things were also added here. So that, can you read section 7.3a? Let us go to section 7.3a and let us see what is written there. Because in order to appreciate this case, I think a quick reading of section 7.3a will be fruitful for all of us. Just a minute. Whenever you go to any case law,
Yes, sir.
you again go
Yeah.
back to the
Yes, sir.
Provisionality
I'll
Act
read it,
also.
sir. Shall I read it, sir?
Just a
Ah,
minute, let me share. Let me
Yes,
share.
sir.
I think. So section 7.3a. I hope my screen is visible now. Section 7.3a. I will not do it for all the sections, but somewhere we can, so that I am just telling you the way to read things. Section 7.3a. So what it says? This is section 7.3. So what it says? Section 7.3a says, just a minute. क्या कहता है सेक्शन 7.3 ये the financial creditor shall, along with the application, furnish a record of the default recorded with the information utility. So the NCLT put stress on the word shall. So they say that this is mandatory because the word shall means mandatory. Along with the application, furnish record of the default recorded with the information utility or such other record or evidence of default as may be specified. So it's clearly written. So 3A. So this was a case law on section 7.3a. It says record of the default recorded with the information utility or such other record or evidence of default as may be specified. Now the question before NCLT was whether it is mandatory to produce this, whether it is mandatory to furnish this record of the default recorded with information utility. NCLT said yes, but High Court said no. Okay? High Court said that the word or has been used and other records can also be produced.
Yes.
This was the main issue. ठीक है जी, so we were here, यहाँ पर थे. So jurisdictional overreach by NCLT. Then interpretation of section 7.3a, the use of or and retrospective application was held invalid. Inherent powers of NCLT. So NCLT cannot use its inherent powers because rule 11 of the NCLT rule says that the NCLT has got some inherent powers. And in the examination, they sometimes ask question on rule 11 also of NCLT rules to introduce procedural requirements that conflict with statutory provisions. So can anybody read this NCLT rules, in rule 11 of NCLT rules? Anyone who is having rule 11 of NCLT rules? Because I don't have books here. So rule 11 पढ़ सकते हैं आप कोई भी, नहीं तो गूगल चाचा से पूछ लीजिए. रूल 11 ऑफ एनसीएलटी रूल्स क्या बोलता है भाई, एक बार पढ़ेंगे तभी तो समझ में आएगा ना क्या है. So it gives the some inherent powers to NCLT, like Article 141 gives the powers to Supreme Court to decide anything which helps in rendering of complete justice. Similarly, Rule 11 is there, which gives the power to NCLT. Yes, please.
Rule 11 of NCLT Rules 2016 grants the tribunal inherent powers to make orders necessary for the ends of justice or to prevent abuse of its process.
Right.
These are residual powers that allow the NCLT to pass orders not specifically covered by the rules, but they cannot be used to review or alter its own past decisions or to decide matters on facts already determined.
Right. Then non-mandatory nature of section 215. So section 215 is also there. Section 215 talks of the submission of financial information. So it says it is not mandatory for financial creditors. So section 215 also we can read. We can do a quick reading of section 215 also. So what, Pooja ji, can you read
Yes,
from the
sir.
Bear Code, section 215?
So it says procedure for submission, etc., financial information.
Right.
Any person who intends to submit financial information to the IU or assess the information from the IU shall pay such fees and submit information in such form and manner as may be specified by regulations. A financial creditor shall submit financial information and information relating to assets in relation to which any security interest has been created in
Hmm.
such form and manner as may be specified by the regulations.
Hmm.
An operational creditor may submit financial information to the information utility in such form and manner as may be specified.
Hmm. So the stress was on the word shall here. So it is using the word shall for financial creditors and using the word may for operational creditors in section 215. So but they say it pertains to submission of financial information. So they are not establishing the default here. So that is the difference between section 7 and section 215. So Calcutta High Court struck down the NCLT's directive declaring it ultra vires, the IBC 2016. Now Rajiv Chakravarti. So this is a case law on PMLA also. So Rajiv Chakravarti, he was the resolution professional of this Enviro Industry, ERA Infra Engineering Limited, EIFL versus Directorate of Enforcement. So what was the case? Here, the ED froze 74 bank accounts of this company and insolvency proceedings commenced. Adjudicating authority upheld the freezing of bank accounts. ED attached 49 bank accounts under PMLA. Adjudicating authority confirmed the order of attachment. Corporate debtor received an income tax refund. And ED attached to tunnel boring machines also. ED attached the income tax refund also. Then contempt petition was filed by the petitioner. Contempt petition was dismissed and Supreme Court stayed further CIRP proceedings. And Supreme Court vacated the interim stay on CIRP. So this was the sequence of events. So one of the main issue is interplay between IBC and PMLA. So it says when section 14 is invoked, then whether the enforcement directorate can attach the properties. This was one of the issue. Second was jurisdiction of NCLT, whether the NCLT has jurisdiction to rule on the validity of attachment orders issued under PMLA and impact of section 32A of the IBC. So whether the protection under section 32A of IBC extends to attachments made by the enforcement directorate under PMLA. So these were the issues. Anybody, what is the section 32A? Anyone? 32A क्या है? 32A grants immunity to the erstwhile management. So they say there is one existing management and then there is new management. So it says that the new management or the company which has acquired the assets pursuant to an approved resolution plan is granted immunity unless they are hand in glove with the previous promoters or they are also involved in this hanky-panky. So this is in brief section 32A. So it says whether the section 32A of IBC extends to attachments made by the enforcement directorate under PMLA. This was also the issue. Now regarding this interplay between IBC and PMLA, so it says section 14 does not prevent the enforcement directorate from attaching properties of a corporate debtor under PMLA because they say that PMLA proceedings are distinct from the IBC and serve a different legislative purpose. Okay. One important question here. When was this PMLA law came into force? ये PMLA कब आया था? PMLA is an old law, although it was made effective quite recently. PMLA law कब आया था? Anybody? ये law आया कब था? लॉ तो पुराना है मेरे हिसाब से, लॉ ज्यादा नया नहीं है. प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट कब का है ये, पूजा जी?
So I think 2002.
नहीं, आप सर्च कर लो ना, एक्ट के आगे नाम लिखा होता है, पूरा प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट के ईयर लिखा होता है।
सर 2002 ही है।
हाँ जी,
2002.
हाँ, तो देखो आईबीसी से पहले आया हुआ ये। हाँ, बट ये है कि बहुत ज्यादा इफेक्टिव नहीं था, रिसेंटली इफेक्टिव हुआ है। ठीक है। अनदर पॉइंट वाज रिगार्डिंग दिस जुरिसडिक्शन। देखो ऐसे ऐसे सवाल पूछ लेगा वो आपसे, आप पूरा रटते रहोगे, वो सवाल आपसे पूछ लेगा पीएमएलए लॉ आया कब था, अब कहेगा यार स्टूडेंट को यही नहीं पता आया कब था। Jurisdiction of NCLT. NCLT doesn't have jurisdiction to rule on the validity of attachment orders issued under PML. The proper forum to challenge such orders is the adjudicating authority under the PMLA. Because there is a concept of adjudicating authority under PMLA also. So they said NCLT doesn't have jurisdiction to rule on the validity of attachment orders issued under PMLA. Because they are operative in different fields. Next is
पीएमएलए के लिए एजुकेटिंग अथॉरिटी कौन है फिर सर?
नहीं, पीएमएलए के तो एडजुडिकेटिंग अथॉरिटी अलग है ना, वहां पर क्या है, उनके कोर्ट्स
Right.
अलग हैं, पीएमएलए कोर्ट्स हैं।
ओके.
हाँ,
सर वहाँ
Impact-
पे
हाँ जी,
ईडी है ना सर, एनफोर्समेंट डायरेक्टोरेट।
हाँ, एनफोर्समेंट डायरेक्ट एक्चुअली क्या है, वहां अथॉरिटीज बनाते हैं ना, वहां भी बेंचेस बनती हैं, पीएमएलए में भी बेंचेस बनती हैं, उनके अलग कोर्ट्स हैं।
ओके सर.
इम्पैक्ट ऑफ वो एनसीएलटी में नहीं जाते मैटर। इम्पैक्ट ऑफ सेक्शन 32A ऑफ आईबीसी, द प्रोटेक्शन अंडर सेक्शन 32A ऑफ द आईबीसी व्हिच प्रोवाइड्स इम्यूनिटी टू द कॉर्पोरेट डेटा फ्रॉम प्रोसिक्यूशन फॉर प्रायर ऑफेंसेस once a resolution plan is approved does not extend to attachments made by ED under the PMLA. If we read section 32A, in section 32A also it says that if any proceeding is going on and in which a report has been filed, so that is not covered under section 32A. डायरेक्ट रेफरेंस है 32A में, है ना। The legislative intent behind section 32A was to facilitate the revival of the corporate debtor by providing a clean slate for the new management, but it does not interfere with the actions taken under the PMLA to deal with proceeds of crime. ठीक है, अब इतना रामायण पढ़ लिया हमने, तो एक बार सेक्शन 32A को भी पढ़ना तो बनता है ना। भाई हम बार बार पढ़ रहे हैं कि 32A 32A, तो 32A पता भी तो होना चाहिए है क्या।
Liability for prior offenses, sir.
हाँ, तो ये आ गया ना। एक मिनट, मैं जरा इसको कंट्रोल F करके सेक्शन 32A कर, और सेक्शन 32A की ब्यूटी क्या है कि वहां पर कोई वो है नहीं। एक मिनट, क्या हो गया, इसमें कोई रेगुलेशन नहीं है। एक मिनट, क्या हो रहा है, बार बार मैं उसी को शेयर कर रहा हूँ। एक मिनट, अपडेट भी होना ये है वो, तो इसमें कंट्रोल F करके मैं क्या करूंगा, यहाँ सेक्शन 32A लिख दूंगा। नहीं नजर आ रहा तो ये है जी 32A। तो 32A में आप देखो डायरेक्ट रेफरेंस मिलेगा आपको। मैं वही चीज आपको पढ़वा देता हूँ। 32A में कहा ये बात लिखी गई है, क्या लिखा है? सबसे पहले ए पर्सन विद रिगार्ड टू whom द रिलेवेंट इन्वेस्टिगेटिंग अथॉरिटी, तो ये इन्वेस्टिगेटिंग अथॉरिटी किसकी बात कर रहा है, पीएमएलए की, हैज ऑन द बेसिस ऑफ मटेरियल इन हिज पोजेशन रीजन टू बिलीव that he had abetted or conspired for the commission of the offense and has submitted or filed a report or a complaint to the relevant statutory authority or court. So they say it does not grant immunity to these persons. ठीक है, तो ये पॉइंट इंपॉर्टेंट है। So suppose there is some investigating authority and they have got material in its possession, and they have reason to believe that this person had abetted or conspired for the commission of the offense. And this investigating authority had submitted or filed a report also, or a complaint to the relevant statutory authority or court. So in that case, this immunity, which is otherwise available under section 32, is not available. ठीक है, ये पॉइंट। अब चलिए चलते हैं दोबारा अपना केस पर। ठीक है जी, तो ये पॉइंट है। Now, see the next case. Venkata Sivakumar versus Insolvency and Bankruptcy Board of India. This case law is based on the concept of authorization for assignment. ठीक है, अब authorization for assignment तो ठीक है, लेकिन आप बताइए कि which article of the Constitution was discussed here? इस केस लॉ में कौन सा आर्टिकल कॉन्स्टिट्यूशन का डिस्कस किया?
Article 14, Article 19, 1G and 21.
राइट। तो आर्टिकल 14 क्या है हमारा? आर्टिकल 14 क्या बोलता है? इक्वेलिटी, इक्वेलिटी बिफोर लॉ। आर्टिकल 14 क्या है?
Right to equality, sir. Right to 19 is right to life and liberty, है ना सर?
और आर्टिकल 19 क्या है? फ्रीडम ऑफ बिजनेस एंड ऑक्यूपेशन।
Freedom of, हाँ जी।
तो ये है, ये बोल रहा है आर्टिकल 14, 19, 1G और 20। वो आपसे आर्टिकल का नाम पूछ लेगा कि आर्टिकल 14 डील्स विद दिस थिंग, वो 3-4 चीजें दे देगा नीचे, या बोलेगा आर्टिकल 14 डज नॉट डील विद दिस, या तीनों ही दे देगा। आर्टिकल 14, 19, 1G एंड 21 दे डू नॉट डील विद दिस। एक एक पॉइंट इनका डाल देगा तीनों का, एक कोई और चौथा पॉइंट डाल देगा, ऐसा भी पूछ सकता है। ठीक है, आर्टिकल 21 क्या है?
Right to life and liberty, sir.
और आर्टिकल 19, 1G फ्रीडम
Freedom
ऑफ बिजनेस एंड ऑक्यूपेशन।
हाँ जी।
और आर्टिकल 14 राइट ऑफ इक्वालिटी। राइट, आर्टिकल 14 क्या है?
Right to equality, sir.
हाँ, है ना? तो ये चीज, अब वो क्या करेगा, इसके अलावा भी कोई राइट डाल दे, है ना? तो इस तरह से भी आपसे सवाल पूछ सकता है भाई। अब उसको भी पता है, वो नेक्स्ट लेवल पे जाना चाहता है, एग्जामिनर भी। एग्जामिनर को पता है ये तो सारे पढ़ के आएंगे ही भाई, ऑथराइजेशन फॉर असाइनमेंट पे था। बट अपार्ट फ्रॉम दैट, आपको हर एक केस लॉ के बारे में यू मस्ट रिमेंबर 2-3 इंपॉर्टेंट थिंग्स, है ना? जो है वो तो है ही है, ऑथराइजेशन फॉर असाइनमेंट तो है ही है, उसके अलावा भी क्या है और उससे क्या क्वेश्चंस फ्रेम हो सकते हैं, आपको उस तरह से याद रखना है। So he was basically practicing chartered accountant and IP. He challenged the constitutional validity of Regulation 7A because Regulation 7A said it came later. So it said that he must obtain an authorization for assignment before undertaking any new assignments. Okay? And then bylaw 12A, it outlines the criteria and procedure for obtaining an AFA. So the point here is, they can also ask you a question like this. Suppose you are an insolvency professional, whether it is necessary, whether it is mandatory for you to obtain an AFA, what will be your answer?
Yes, sir. It is mandatory, sir.
No, it is not.
Okay.
It is mandatory only when you want to undertake any assignment. So there could be a situation where you are an insolvency professional, you have passed the examination, you have obtained registration also from IBBI, but you don't want to practice. So if you don't want to practice, then you don't need IFA. It is only needed when you want to practice. This is very important thing. They may ask you this thing also. भाई IBBI भी बोलता है भाई तुम्हें प्रैक्टिस करनी है करो, नहीं करनी ना करो, हमें तो फीस दे दो बस, है ना? अगर वो सबके लिए कहते हैं कि भाई AFA लेना जरूरी है, फिर तो अब some people are in job also, they don't want to leave their job, है ना? तो while in job also you can become an insolvency professional. भाई IBBI की तो फीस से मतलब है ना, तुम भाड़ में पढ़ो, तुम्हें क्या कर रहे हैं, क्यों? ये AFA जो है, AFA की कॉन्सेप्ट उनके लिए है जो प्रैक्टिस करना चाहते हैं।
AFA can be frozen, sir. मतलब
yes, surrender also is there. There is temporary surrender also. there is permanent surrender also. That concept is there. वो तो है ही.
But temporary surrender मतलब you have to pay the fees.
भाई वो freezing जैसे अब suppose electricity connection you have got, you are going abroad say for 6 months, so then you temporarily surrender your electricity connection. Now this is something similar.
Right.
Yes. So what was the court findings? So court held that IBBI had the statutory authority under section 196, 207, 208 and 240. Then reasonableness of the AFA requirement. So it says that it is a reasonable regulatory measure to ensure the integrity and professionalism of IPs aligning with the objectives of the IPC. Validity of legislation. The court found that the delegation of certain functions to IPAs was within the permissible limits and did not constitute excessive delegation. Because who is allotting IPAs? Who is allotting this AFA? AFA is being allotted by IPA.
IPS.
ऐसा भी पूछ सकता है कि AFA देता कौन है? IBBI देता है या IPA देता है? ऐसा सा कभी सवाल पूछ रहा था सिंपल, हमें कॉम्प्लिकेटेड का आंसर आता है, कई बार सिंपल का नहीं आता है ना. बस सम पीपल मे टिक IBBI, भाई IBBI करता होगा नहीं, आपको पढ़ना है किसने करा, IPA. ठीक है. Clarity of criteria. The eligibility conditions for obtaining an AFA were considered clear and appropriate, serving the purpose of maintaining high professional standards. Appeal mechanism. So while upholding the validity of the 7-day appeal period, the court suggested that IBBI may consider amending the regulation to allow for a longer appeal window or provisions to condone delays, enhancing fairness in the process. तो पहले क्या था, 7 days का था, अभी कितना है, 15 days का. अभी लेटेस्ट पोजीशन क्या है पूजा जी ऑन दिस अपील मैकेनिज्म? Suppose AFA is rejected, then you've got right of appeal also. It was earlier 7 days, then it was enhanced to 15 days. So what I want to confirm from you is whether it is still 15 days or there is some other amendment also.
I think it's 15 days only.
नहीं थिंक तुम कुछ नहीं होता, आप देखो बुक से पढ़ के बताओ. भाई उसी बहाने रेगुलेशन को पलट लोगे ना आप.
Yes.
और कोई भी, सारे सत्संग तो सारे सुन रहे हैं, कोई भी बुक खोल के बता दो.
हाँ.
भाई कथा में तो सारे श्रोता बैठे हैं, जिसके पास भी बुक है सॉफ्ट कॉपी हार्ड कॉपी, कम से कम पता तो चल जाएगा ये प्रोविजन डिस्कस कहाँ किया गया है. हाँ जी. भाई कहीं तो लिखा ही होगा इसके बारे में. हितेश देसाई जी आप बताइए. निशा जी, आई हैव गॉट हाई होप्स फ्रॉम यू. अच्छा पढ़ रहे हो आप.
The regulation 8 में I think it will be applicable.
कोई बात नहीं, 2 मिनट लगा लेते हैं, कोई फर्क नहीं पड़ता, कोई जल्दी थोड़ी है हमारे.
Regulation 8 में ऐसे refusal to grant certificate.
हाँ ठीक है.
If after considering an application made under Regulation 6, the board is of the prima facie opinion that the registration ought not to be granted, it shall communicate the reasons for forming such an opinion and give the applicant an opportunity to explain why its application should be accepted within 15 days of the receipt of the communication from the board to enable it to form a final opinion. The communication under subregulation 1 shall be made to the applicant within 30 days of receipt of the application excluding the time given by the board for presenting additional documents, information, or clarifications, or appearing in person as the case may be. After considering the explanation, if any, given by the applicant under sub-regulation 1, the board shall communicate its decision to accept the application along with certificate of registration, reject the application by an order giving reasons thereof within 30 days of receipt of the explanation.
वो एक अलग कहानी है, ये अलग कहानी। ये रिजेक्ट हो गया आपका फेयर, अब आपको अपील करनी है।
ये कौन सी रेगुलेशन है, कौन सी हेडिंग में है ये सर?
हाँ जी,
सर ये जो रेगुलेशन अभी रीड आउट करा है वो कौन सी हेडिंग से लिया है?
पूजा जी पढ़ रहे हैं आईपीए रेगुलेशंस में से।
आईपीओ।
IBBI Insolvency Professional Regulations 2016. ये रेगुलेशन 8 है, refusal to grant certificate.
हेलो, मेरी क्लास चल रही है मेरी।
Sir, is it 30 days now, sir?
भाई चलो ग्रुप में लिख देना, ठीक है, साइटिंग दी रेलेवेंट रेगुलेशन। चलिए भाई, इसी बहाने पढ़ लोगे ना, और क्या। नाउ सीए वेंकटा शिवा कुमार वर्सेस इंसॉल्वेंसी एंड बैंक्रप्सी बोर्ड ऑफ इंडिया। नेक्स्ट केस, ये भी सिमिलर केस है। इसमें क्या था बेसिकली, एंड हाउ इट इज डिफरेंट। देखो दो केस है, पहला ये है सीए वेंकटा शिवा कुमार वर्सेस आईबीबीआई एंड अदर्स, और चौथा केस क्या है, ये सीए वेंकटा शिवा कुमार वर्सेस इंसॉल्वेंसी एंड बैंक्रप्सी बोर्ड ऑफ इंडिया। अब इसमें क्या कहा, इसमें सेक्शन 207, 208, 240, ये पावर बोर्ड की पावर को चैलेंज किया बेसिकली, ठीक है। So regulation 7 it deals with the requirement of insolvency professionals to hold a valid AFA. Regulation 12 details and procedure and criteria for issuing an AFA. Regulation 7(2)(CA payment of fees calculated at 0.25%. 1% is now, है ना? And then regulation 13(2)(CA payment of fees calculated at 0.25%, which is 1% now, of the turnover of the IP in the preceding financial year. So बेसिकली क्या है, वो तो पॉइंट लिए वो पहले भी लिए थे एएफए वाला, यहाँ फीस को भी इंक्लूड कर लिया कि भाई फीस क्यों ले रहे हो बोर्ड से, टर्नओवर के बेसिस पर फीस क्यों ले रहे हो आप। ये बोर्ड को चैलेंज किया इसने, ठीक है, ये मेन पॉइंट था। नाउ रिगार्डिंग द कॉन्स्टिट्यूशनल वैलिडिटी ऑफ रेगुलेशन 7(2)(CA which allows the IBBI to charge a fees calculated at 0.25%, which is 1% now, of the professional fees earned. So it says it is constitutionally valid. It falls within the powers conferred upon the IBBI by section 196, 207, 208 and 240. Regulation ensures that insolvency professionals contribute to the regulatory framework that maintain high